So, today the Supreme Court of India made a landmark decision that no new mining leases in the Aravalli region, at least until a scientific mapping is done. But what does this mean for ecology, mining, and future development? Let's break it down. The Aravalli Hills and ranges stretch across four states: Delhi, Haryana, Rajasthan, and Gujarat. Historically, there has been large scale illegal mining in these hills, with different states using inconsistent definitions of what counts as Aravalli Hills. This lack of clarity contributed to environmental degradation and regulatory gaps. So, a three judge bench led by Chief Justice P.R. Gavai accepted definitions of Aravalli Hills and ranges proposed by a government committee. According to the adopted definition, Aravalli Hills are any landform in designated districts with an elevation of at least 100 meters from the local base terrain. Aravalli ranges are defined when two or more such hills lie within 500 meters of each other. The court rejected a complete ban on mining, noting that an outright prohibition could drive mining underground, that is, illegal mining. So, what the court ordered in this matter, the Supreme Court has directed the Ministry of Environment, Forest and Climate Change to prepare a management plan for sustainable mining for the entire Aravalli region through the Indian Council of Forestry Research and Education. This plan must include identify which areas are ecologically sensitive, conservation critical, or restoration priority, and decide where mining can be allowed only in exceptional scientifically justified cases. Second one is analyze cumulative environmental impacts and assess the ecological carrying capacity. For example, how much mining the region can sustain without irreversible harm. Third one is lay out detailed post mining restoration and rehabilitation measures so that mined areas are not abandoned but restored. Importantly, no new mining leases can be granted until this management plan for sustainable mining is finalized. For existing mines, they can continue operating but only under strict compliance with the committee's recommendations. The significance of this area and why this matters. The Aravalli region is ecologically crucial. It houses 22 wildlife sanctuaries, 4 tiger reserves, and several wetlands. It also supports aquifers that recharge rivers like Chambal, Luni, Mahi, Sabarmati, and Banas. By mandating scientific mapping first, the code is pushing for evidence based, sustainable mining rather than unregulated extraction. This approach could help strike a balance between ecology and economic activity, allowing mines where possible but protecting the most sensitive areas. Let's understand challenges and risks involved in this. Scientific mapping and ecological assessment take time. There is a risk that states may delay or restrict certain restrictions. Even existing mines need to follow stricter rules. If these are not enforced well, environmental damage could continue. There is an economic dimension to it also. Mining supports livelihood. A complete or even partial restriction can affect jobs, especially in mining dependent regions. The rehabilitation plan needs to be credible. Restoring mined lands is often complex and costly. Coming to conclusion of this video, the Supreme Court decision is a big win for environmental governance, but the real test lies ahead. Will the management plan for sustainable mining actually preserve the Aravalli's ecological integrity while allowing responsible mining? Only time, science, and strong implementation will tell. Let me know what you think about it. Should mining be allowed again in Aravalli if it's done sustainably? Comment below and don't forget to like and subscribe for more such legal environmental deep dives. Thank you.